This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today, we're speaking about something serious. Shooting someone to death is usually not an accident and is an injury in the course of self-defense, an occurrence. Where there is no accident, the intentional acts exclusion becomes irrelevant. The case involved a tragic incident where Kimberly Mollicone was killed during a gunfight between her husband, Matthew Mollicone, and Daniele Giannone. The central issue, whether Giacone's actions taken in self-defense are covered under his State Farm homeowner's insurance policy. In State Farm Fire and Casualty versus Daniele Giuseppe Giannone, Heidi C. Aull, personal representative for the estate of Kimberly A. Mollicone, the United States Court of Appeal for the Sixth Circuit on August 5, 2025, resolved the issue. Although rare in insurance contracts, the policy in question provides coverage for the insured's liability to third parties who are injured in an accident. State Farm's policy includes a self-defense exception to the intentional acts exclusion. The Sixth Circuit discussed various legal precedents and interpretations of the policy language, focusing on whether actions taken in self-defense can be considered occurrences under the policy. Appellate courts generally held that the intentional actions taken in self-defense are not accidental and therefore do not constitute occurrences under the policy. The decision explored the interplay between the personal liability coverage provision, the intended acts exclusion, and the self-defense exception. It highlighted the importance of interpreting the insurance contract as a whole to honor the intent of the parties involved. Ultimately, the court affirmed the district court's decision that Giannone's actions did not qualify as an accident, and therefore State Farm had no duty to indemnify or defend him in the state court litigation. The key issue before the Sixth Circuit, whether Ms. Mollicone's shooting constituted an occurrence, the policy defined an occurrence as an accident that results in bodily injury or property damage. Ms. Mollicone's estate and Giannone argued that while Giannone intended to fire the gun, he did not intend to injure or aim at Ms. Mollicone, and her injuries are therefore a covered accident. Michigan law, where the action occurred, defines an accident for purposes of interpreting insurance contracts as an undesigned contingency, a casualty, a happening by chance, something out of the usual course of things, unusual, fortuitous, not anticipated, not naturally to be expected. Generally, an accident may include an unforeseen consequence of an intentional act, but unforeseen consequences are not accidental when the intended act created a direct risk of harm from which the consequences should reasonably have been expected by the insured, unless the policy language specifies otherwise. Michigan uses a subjective standard, meaning the appellate court must look to whether the insured should have reasonably expected the consequences of his act. To prevail, then, Ms. Mollicone's estate and Giannone must show that Ms. Mollicone's death was not a foreseeable result of aiming and shooting a gun at the vehicle she occupied. The Sixth Circuit concluded that they cannot make that needed showing. Giannone aimed his loaded gun at Mr. Mollicone and fired, expecting a bullet to leave the chamber. The act took place as intended, even if Giannone desired a different result. Giannone subjectively intended to cause harm, just not the harm that ultimately came about. Accordingly, Giannone's conduct was not accidental and not a covered occurrence. Ms. Mollicone's estate and Giannone next argued that the analysis changes if Giannone was plausibly acting in self-defense. Along these lines, Giannone claimed that he saw a gun poke out of the passenger window and out of concern for his and his family's safety fired back. At the stage of the appeal, the factual record was not developed enough to determine whether Giannone acted in self-defense, but the Sixth Circuit did not need to reach the question of self-defense because such a determination would not affect State Farm's liability. The Sixth Circuit noted that the Michigan Supreme Court has held that actions taken in self-defense are intentional. In the case cited, an insured must intentionally shoot an intruder who he had reason to believe was armed and intended harm. The court held that the insured's actions were not covered under his insurance policy because actions taken in self-defense were different from those that are purely accidental and excluded as intentional acts. The reasoning implied that under Michigan law, intentional actions taken in self-defense are not accidental, and thus they do not constitute an occurrence. And if there's no occurrence, there's no coverage. Mrs. Mollicone's estate and Giannone are wrong to suggest it matters if Giannone was acting in self-defense. Even if Giannone were validly acting in self-defense such that the events fall into the exception to his intentional acts exclusion, his actions were not accidental. So the occurrence provision still precluded coverage. In sum, Ms. Mollicone's death was a direct result of Giannone's foreseeable actions, and therefore Ms. Mollicone's estate and Giannone cannot show that Giannone's actions fall under the policy's definition of an occurrence without which coverage cannot exist, making the intentional act exclusion surplusage. Because Kimberly Mollicone's death was the direct and foreseeable result of Giannone's actions, there was no coverage under the policy. In my opinion, occurrence as defined is the key to every liability insurance contract. If there's no occurrence, no accident, there can never be coverage, and there is no need to consider exclusions, because the first requirement of actual coverage doesn't exist. This video was adapted from my blog, Selma on Insurance, which is available free to anyone who clicks on the URL selma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll also gain access to the more than 5,150 blog postings. Please tell your friends and colleagues about this blog so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider for a very small fee subscribing to my Substack publications. And if you're watching on YouTube or on rumble.com, please click on the like button on YouTube or the thumbs up button on rumble.com. Thank you for your attention.